the answer immediately. Who's your daddy and what does he do? Now, I'm not going to talk about Arnie. I'll demonstrate that's my actual skill, speaking like Arnie. We're going to talk about technology and ethics, and we're going to do a bit of double take. So I'm going to say my piece, and then cut to Michael. We're going to do a bit of tag team wrestling here, and hopefully no one gets knocked out during. So now, both Michael and I, besides being a practicing bachelor lawyer, obviously heavily in the technology space. But I think, and I'm not 100% on what Michael's views are on these things, I think we're fairly aligned. But I'm going to put forward some views that I think might be a little bit more conservative than you might hear from your general tech client. Now, I would hope that all of the cool stuff that I do in legal tech gives me innovation credentials, and so you know that I'm heavily invested in doing new things by virtue of skin in the game. But on the other hand, as a lawyer, it's really important to make sure that we have the correct skin in the game. So we're going to start off on a weird space. The technology is inevitable. So there's a concept called emergence. That is to say, things happen as if they have been organized but by a number of independent people or parties acting without knowledge of each other or coordination. For example, memes, changes to language.
Robin Hood films.
Pardon?
Robin Hood films.
Robin Hood films, yes, yeah, Robin Hood films.
The animated films about bees.
Of course, we think that this is a fantastic new thing. Ants. Ants is a fantastic idea. A prairie is an emergent thing. But technology is also an emergent property. That is to say, while we like to think that we're, Steve Jobs is special and Microsoft is special, everyone is creating new pieces of technology simultaneously with combustion engines. There were half a dozen other people who were developing combustion engines at the same time. Same with light bulbs. If it wasn't for Thomas Alva Edison, any one of the other dozen people who had similar patents around at the time, including some that he bought, would be credited with it. Aircraft, and the
food delivery services.
Pardon?
Food delivery services.
Food delivery services, yes. The Formula 1 mile after Roger Bannister won it, beat that record, 6 weeks later, Landy did, and then in the next year, 17 people did. So throughout all of human history, no one could run the mile in more than 4 minutes, and then suddenly, in 1 year space, 17 people did. The same happens with technology. Google, Facebook, and Uber could have been Alta Vista, MySpace, or Lyft, or Beto, Weibo, and Didi. Any of those could be the dominant things. So the first thing is that as a legal technologist, I don't think I'm particularly special. I think that if I died, as much as the things I think that I've done, if I died tomorrow, someone else would do it instead. What are your thoughts?
I agree with that. But the problem about inevitability, I think, is that there's another risk about thinking that things are inevitable, and that's that we are victims, or that we are subject to knowing to shape things. So I think we need to be very careful that when Adrian's talking about inevitability or simultaneous development or emergence, we're talking about the collective effects of human effort rather than the ability of humans to shape technology. That is, that we as humans should be the shapers and the creators of technology, be aware that we have choices and we can make choices. And I think that's something that returns as a theme, but it's a very important idea. So saying that things are inevitable doesn't mean there's a corollary that we're unable to change direction or shift focus. And what we're talking about today about ethics is a critical aspect of that. As humans, we can answer the question, we should be able to answer the question, and the answer should have an effect as to what sort of society we want to live in. That's important. Sorry.
No, please. The idea is it should be approximately, so 5 forward.
Well,
yeah, keep going.
we use the egg time.
Egg time, okay, cool. Pushing on a string. This is an economic metaphor about inflation and the economy. You can pull on a string, but you can't push it. So legal technology innovation is something that we can pull on a string, we can stop. But a regulator can't push on the string. You can't force Australians to innovate. I'm sure if you've been running the legal technology department, you probably understand how difficult it is to get someone to create something. Obviously, there's opportunity cost for lawyers. But the important thing here is that creators impress themselves subtly upon the technology they create. So technology is like an art rather than a science. It's not just something that you go out and you do research and you find and you divine the right piece of technology. Instead, you will make thousands of tiny little choices along the way, and your ethical outlook will be impressed in a subtle and almost indistinguishable way on the technology. So I think that there is a potential huge difference in who creates legal technology. If legal technology is created by Silicon Valley-backed VC versus, say, an authoritarian government-backed company, or a person who is involved, who has been impressed with an Australian or Western legal morality and view of the law. Now, I think it was Chile IQ, I spoke recently for one of their blockchain conferences, and now I've been writing tech stuff like that for a while, and spoken in this space. But I'd say about 40% of people in the crypto space are expressly extreme anarchists who believe that all of the government can and should be replaced by something on the blockchain ledger. Another space is in legal technology. I know some technologists who have the view of creating law free everywhere, but are going to do so by cross-selling insurance and banking products and stuff with people. Now, as a lawyer, I find that a terrible idea. It's like, so the technology itself is inevitable, but the way it presents itself is not. And so there are some potentials that I find ghastly when I think of the rule of law. Now, what are your thoughts? Okay. Then come to the rule of law. Then certain decisions you might make, you might say something is allowable or not. Now, most technology that is built is either uses or is a subset of technology that has been developed by the big 9 technology companies, Facebook, Apple, Microsoft, etc. And so it would be difficult, in my view, to say, here is something that has newly been created. Like, here is a chatbot. Does this give legal advice? Well, if you're going to form that view, you might have to look at Google and apply the rule of law and ban Google, which we're now going to talk about. Would you like to talk about search engines at Google?
Well, that's a large problem. So when we created Jade, obviously Jade is a search engine of sorts, but it's meant to be so much more. And we did it because people would plug things into Google to do their legal research. Just to take a show of hands, how many people think that more than 70% of people start their legal research as lawyers on Google? How many people think more than 80% do? Well, the correct number is about 85%. And people, and one of the problems is, of course, if you, and this is in law firms as well, if you ask a lawyer how do they do legal research, they will give you the reversed answer, just as if you ask a doctor, do they wash their hands before they do surgery? They'll say, of course I wash my hands every time I touch a different patient, but the reality, having watched people, and the reality in just the statistics about how many people come to jail from Google is quite different. So the reality, the practices of people are to very heavily use Google to find things. And the risk, of course, many times in using Google to do legal research is they find something that's out of date. But the classic example that people used to use Ostley to do, and of course use Jade and others, is to find a case that's been overturned on appeal. So they go, this is a fantastic case. It supports everything I wish to say. It's exactly what all fours with it. The only problem, of course, is that 2 or 3 or 6 months or a year later, a full court had already turned that decision and ruled against it, or the matter's gone to the High Court. So there's a real risk in contextualising information. Now, does that mean that we as a society expect flashing lights to go up on Google to say don't use Google to do legal research? Or what about options? What do you think, Adrian?
Well, I was going to put it back to you as a question. I was just formulating. So, I think there should be a differentiator between law, practical law, and things that are law-ish, such as your search engines, because they do provide, as you say, an entry to law. And there is a place for regulation of them, but to a totally different extent. So the question I was going to ask for you is should a legal publisher have an obligation to sort things and provide a way of checking whether something is out of date? And so that would apply to you, standard legal publishers, and to my understanding, Jay is excellent at doing that, but then would that also apply to search engines such as Google?
Well, I think there's a responsibility to do that. One of the problems of, for example, Google is that it gives an international answer. Sometimes it gives localizations, but it generally gives an answer that's international. So in some cases, the answer that someone might get might apply if they happen to be resident in the United States rather than in the state of the United States rather than Australia. So it's a good problem. I think it's a very difficult problem to solve, and it requires a level of education about what's called digital literacy. So what law schools in the UK are doing at the moment, through work done by the Library Association there, is trying to formulate what would be legal digital literacy. So trying to impose upon law students at a very early stage an awareness of the risks of using one or other platform and the risks of simply accepting what spits out of a search engine. So it's really trying to unlearn the habits that those students learn when they're perhaps at university, if they're at the late stage of their career, or certainly unlearning the things they've learned whilst in school. And that process, I think, is a really important one, because it allows us to identify what it does mean to do legal research and what it does mean to how to evaluate whether that answer is a generic answer of limited applicability or not. At the same time, as we know that there's Dr. Google in relation to medicines, of course, what's called Google JD in the American context in relation to legal research. So you'll get I have clients sometimes coming to me using American terminology to describe a position, or saying, why isn't it the case here that X applies? Of course, they're citing American statute. So it's a real risk about how to approach that, and I think that's something that's, the Google list hasn't been around for as long as legal research has been. So, we're still evolving and still searching for an answer to that ethical conundrum about how we deal with that kind of problem. But I think turning off Google is not the answer. I'm not sure what the proper answer is.
Could I make a suggestion? I think that where the current problem is the focus is on treating technology as if it's a lawyer. This is my final slide. And so we look to regulate technology as if it's a lawyer. And so here I want to run through some examples of what constitutes legal advice. Now, and this is one of the things everyone gets really excited about. Oh my God, are you giving legal advice? Now, if you apply that rule and say if something is legal advice, then it gets regulated as a lawyer. That doesn't work in technology. Instead, just cutting to my answer, I would suggest that you would say, no, it's clearly not. But instead, if you are providing such a research, you have an obligation to provide, that this is law-ish rather than law, that you have an obligation to provide law-ish services to a certain level of competency. So you might say, Jay has a way of showing whether something has been overturned. That's great. Google, if Google is providing law-ish services, which I think it does, then it should have a requirement to provide them to a certain level of competency. Would you agree?
Yes, I think if you hold yourself out or offering things, then you certainly have that. Yeah. But an example in the law firm space online is the amount of collateral material law firms put up. A lot of it isn't revised once the law changes. This question there about whether there is an ethical obligation on law firms to continuously search through their online materials, the materials made available to others. Not talking about recent databases necessarily, that's the law firm's own problem. but the online material made available to the public, search through that and ensure that it's constantly revised and perhaps removed or something. I think that's a very important aspect of it.
So I'm going to give the example here of if I said, should I sue my brother? And I type that into Google. So Google, now, to my mind, that is someone asking a legal question. Now, Google comes back with an answer, and it highlights one answer in particular that it thinks right. Now,
I mean, you can see why you got that answer, Adrian, because of the kickboxing, and it's also a reason why I'm standing this.
And if you met my brother, you would say the answer is yes. But let's take this back to first principles, because I think law should always be approached from first principles. So what happens if I looked up, instead of using a Google search, I used to look up after the back of the textbook, and I looked for the words brother or sue. That's going to lead me on a legal research. What happens if I put a whole bunch of legislation and cases into Microsoft Word and do a keyword search of the words sue and brother? It's going to come up with something. Again, it's a keyword search. Is that giving legal advice? Well, quite clearly not. Now Google then takes a keyword search and augments it with its NLP algorithms, with user data, with location data, with a whole bunch of other pieces of data. And so now, it's in a way, it's a step up from there. Now, in my view, where you fall on that answer does Google constitute giving legal advice? Depends on what's going to happen over the next 20 years. If you think that this doesn't constitute, this Google search does not constitute legal advice, I can build anything I can imagine over the next 20 years and I don't have a privilege of issues.
One of the interesting things about that result is Justia, as a company, created a legal database for attorneys. So in fact, they're actually trying to, it's like clickbait. So they're trying to get you in to the site to find an attorney for that purpose in the US. But that's a good example. So that's an example of an emerging business model where someone who might think it's okay to type, should I sue my brother into Google to get an answer about what to do, which is as good as the Moneyball or something like that. That's the example.
Other things that seem kind of interesting are really a subset of that. Google question is the high point. So then chatbots, if instead of having a number of searches, it just returns one piece of text, that is there. Clear, that's a subset. That is less than what Google does. I'm not going to show my chatbot. No. Obviously, I built chatbots, and Ailira has forms that are chatbots. Having something with cool NLP, natural language programming, that's just a subset of what Google does. What if you connected up Amazon Alexa? And so I asked, can I sue my brother? And Alexa says, yes, you should. The fact that it's in speech doesn't change that. Now I'm going to step in what I see in my view is where we start crossing the line. If there was an interpreter or reader, and so you go into an office, someone types this in, should I sue my brother? And an interpreter or reader who is expressly doing nothing else but helping you read this, they read that out aloud. Should I sue my brother? Yes. That's not giving legal advice, but because it's very limited. In my view, though, if you went into an office and you speak to your accountant or your lawyer or your friend, and you say, should I sue my brother? And they look on their phone or their computer or whatever, type it into Google or any of the above, and just dribble off that answer, they have given legal advice. Do you agree? No. So even though the answer isn't any different, but it's the fact that there's a person there, and the Legal Profession Acts in various states deal with what a person should do. If a person does that, they are giving legal advice. And of course, if you purport to give legal advice, you would do so. So if I had a really simple program that says, should I sue my brother? And then I'm going to copy and paste that text into a law firm letterhead and send it out. it's purporting to be from a lawyer, that constitutes legal advice. It needs to be clear that you're talking to a robot, that it's not coming from a lawyer. Do you agree?
I think that there's obviously context and at a broad level, that's right. That the way you frame the circumstances.
Yeah. So I mean, there's something that I'm acutely aware of, and I'm chatting to lawyers, I'm chatting to a robot.
Well, arguably, you're chatting to a wizard of monster.
You're
chatting to a human who's pretending to be a robot.
Well, I think then if you're chatting to Wizard of Oz and there's a person in there, they're saying that I'm a robot, so long as they're not saying that they're a lawyer, you're not expecting it to be a lawyer.
That's a problem with the Turing test, isn't it? So
yes.
how do I evaluate? What happens if the robot tells me that I'm talking to a human and I'm expecting to get legal advice? How does that work?
Well, I think that if
there's
you...
paradox with that.
Oh, yeah. So I would say if it purported to come from a lawyer, so having something on the firm letterhead purports to come from a lawyer, even if it's done in an automated fashion.
So if I type on the computer thinking I'm talking to a human, but in reality there's one person that's written a very clever program to fool me to think I'm talking to a lawyer, then that's giving them legal advice, although it is giving them legal advice by a computer.
Yes. Do you agree?
Well, I'm not sure.
I think so, because even though you're purporting to.
Well, that's the interesting point.
Yeah.
Even though the context might be that I would never think a human could give advice of the kind the computer gave, which might be absurd.
Yes.
In the sense of having half-made sentences or something else that might affect.
Yes. It is a conundrum. I mean, on the other hand, if you, I think this is how you should draw the distinction. And I think that if you, let me put some other views, because I don't think mine is the only view. Another view you could take is that there is a sort of humanish position you can take, that once things reach a specific level of complexity, which is, I don't know, the level of complexity is always beyond what the present person understands. So wherever that is, then you say, oh, it's AI, whatever that is, and therefore it's magic, and that's legal advice. Now, if you take that view, it's like, okay, sure, like, I'm not advocating for a particular view, I'm just a blanket level lawyer, and I think we should apply the rule of law. And I think that if you take that view, it's like, cool, take on Google first.
Well, I mean, that's a interesting point, but if you're saying that the question whether something is giving legal advice or not is designed to be protected in the public, that only those that are taking due care and are appropriately qualified for doing it, then you would err perhaps on the side of any kind of advice, regardless of whether it came from a computer or not, is giving legal advice, and leave it in a regulatory sense to the provider of that service to be careful.
So you would say then that this search here should also be
well, I mean, that's as I said, that's the problem with framing.
Yes.
But it is a view, perhaps.
Yeah.
That if the aim is to have a protective ratio to protect the full party from themselves,
yes,
then maybe there is an issue of where does the regulation stop or start. And
I think then I have a suspicion that that's something that a reflex that people will jump to. And then I would say then that you're going to have particular difficulty going, what's the difference between Google and the keyword search? Where is the line? Does Google have specific, what if I have a Boolean search? What if I have a Boolean search with a bit of NLP? Now, I mean, Google's taking a whole bunch of user data and individual things and actually it's a really complex algorithm. That seems to me like it's, if there was something that's, you're listening carefully to what you've been saying over your entire life and using that all to formulate a response to, should I sue my brother? It's taking all of the facts and considerations, it's taking a lot. But then of course the problem is, practically, we come back to technology subversion. Google's revenue is many times the size of any regulator or any legal profession, entire legal profession in Australia. So what, can you stop it?
I mean, practically that was once I was served Google to get some information from Google. An answer came back that you had to serve Google, Google Plex, and that we couldn't serve Google by email, believe it or not. you can only serve Google by fax or in person. And so the idea of a firm here that had no international affiliation serving Google was a very difficult question if that was urgent. And if you were trying to have an order, trying to serve an order that preserved data on Google systems, it was about to complete. So there are some practical issues about the stance taken by major technology companies about jurisdiction and the approach. So I think it is a problem about how you regulate, whether some regulation engages and some regulation doesn't. That's a very difficult problem.
Let me put it to something harder. I have a reasonably good understanding of search technology and so do you in slightly different fields, but like I don't think that I could formulate a way of saying this is this. If Google does this, this is advice, and if it doesn't, then it's not. I just like maybe I'm too dumb in more tech, but I go, look, I spend a lot of time in there, and I don't think that I could. And then so if you go, well, if I was sitting in a regulator's chair, I don't think that I could say this is a clear distinction. Now, to my mind, this is a clear distinction that between some adding a person in there changes it or purporting to give legal information. And I think that if you're going to regulate this, and I do think you should, trying to treat technology like it's a human and saying this is legal advice, it doesn't work. It breaks the, it breaks the technology. It's not human. And I'll talk about some reasons shortly why we shouldn't try to. It's actually terrible. But I think you should have a separate new category, extended reach regulation, in something legal-ish. All right. And the reason why I think that you should, that it's that if you're trying, so one answer is that if you're regulating, you can just say, let's be unclear about this. Let's put the onus on you on working out what it is. We're just going to have some vague rules, because the answer is that if the things are vague, no lawyer will do it. Only technologists will build things. Now, I was at the Australian Institute of Legal Judicial Administration last year, and one of the speakers, Mark Pesci, gave an example of what you could do with blockchain in the future. And he gave an example here of there's a contract and money is held in escrow, and then something legal stuff happens, and at the end of it, money gets passed on. Everyone's like, this is a fantastic idea, wow, cool, blockchain. And I was like, well, wait a second. If you, like, at least in South Australia that I'm aware of, if there was a lawyer involved in this, they're involved anywhere in there, there's money held in trust. They need to comply with the transaction in their trust account obligations. They need the BSB of the cryptocurrency, which obviously doesn't. Now they need to take all sorts of boring, mundane banking details, or they have breached their trust account regulations and are potentially liable to huge fines. As cool as an idea as it was, no lawyer in South Australia could do this. You have to be a non-lawyer.
It's the same, an example of the same issue. And of course, because there are so many lawyers in this group, the first thing that anyone noticed on that slide was the misspelling of the word commission. I should.
And that was actually, I got that from a...
I know you do. I Googled it. I wasn't blaming you.
I Googled it. And the consequences of a breach are huge. So let me run past another idea. Well, how long have I got? 2 minutes? Okay. Let me run to a final slide. So this is based on long-tail risks. Now we're going to start with Kim Kardashian. Last year, Kim Kardashian tweeted that the US Statistician General, who apparently knows a lot about statistics, said that the number of people who died by terrorist attacks last year was 7 in total, or 9 in total, and the number of people who died by lawnmowers is 69. Therefore, lawnmowers are more dangerous than terrorists. It's really funny, of course, but we shouldn't get our wisdom from Kim Kardashian. And the reason why is because on the right here we can see our risk distributions. So this is, so here we have the number, so the red ones from lawnmowers, all the distribution of potential outcomes is all clustered around really low outcomes. Somewhere between 5 and 50 people die from lawnmowers, there are 500 and 100 people die from lawnmowers every year. There's no way we could have 10,000 people die from lawnmowers, it's simply impossible. But the distribution from people dying from terrorists could range from 0 to 10,000 to 1 million to 100 million. There's a non-zero chance of 100 million people dying. It is a totally different distribution of risk. Now, lawyers and regulation of lawyers, lawyer problems is a normal distribution like this. If you're a lawyer, what's the worst thing you can do? You can steal from your trust account, you can act conflicted for your client, you could fraudulently create some documents, all these bad things that we rightfully regulate against. And a lawyer can, an individual lawyer or even firm can screw up a certain number of things. Now, a legal technology company could screw up a potentially huge number of things. Totally different things. Like in the blockchain example, it's going to be built in a way such that you can't ever just give the money out of it. Just like a lawyer might pilfer money from their trust account to pay for their pokey, it's going to have, if you have cryptocurrency, it has to be a ledger that everyone that is transparent.
Well, the classic example, of course, is recently the person that died being a person that used the password to unlock the chain. So
yeah,
hundreds of millions of dollars for.
Totally. So it's a long-term risk. Yeah. So you're not going to lose a little of it. You're going to lose everything from that. And as Mike was saying, so the entire blockchain might go down when someone loses their
due to poor password management.
Yeah. So as a regulator, so applying normal regulations to this will stop it, pulls on the string, and doesn't catch the harm that we're trying to prevent. Because there's an entirely new harm with legal technology that I don't think people are discussing. And this is why I wanted to talk about it today. And that is of a very low chance of something catastrophic happening. So if you have something built, there is someone was saying earlier that the legal tech isn't highly, so the law firms are very disaggregated. No one has more than 1%. Well, someday, someone will have 5, 10, 20% of the world global legal market, or will be influenced by a technology company. And then there will be a risk of something terrible happening.
Can I just ask, how many people have read Taylor's Organic Fragility? All right. Well, I recommend you read that and Skin in the Game. Both those books are excellent books. So the reason for doing that, Adrian, is really something I want to pick up on what you were talking about. So as people are now starting to study supply chains and working out that supply chains have become so efficient that they're actually really incredibly fragile, because they are so incredibly efficient in delivering from point A to point B, and so efficient in the economic sense and the organisational sense that they leave no room for any kind of unanticipated event. And Taylor's book about the Black Swan event was the event no one saw coming, and he's developed in a number of ways. You can see that slide, we'll talk about skin in the game. But in the area of the supply chain, the same issue emerges in relation to technology, in relation to everyone going in the cloud. We've seen these enormous cloud outage events, which are just probably a harbinger of things to come. And every time anyone analyses them, they realise when they do the post-mortem, and they say, well, how did this all occur? And of course, it was a series of relatively small insignificant events that no one thought would occur. Now, those kinds of multiplier events, the long tail that Adrian talks about, have been with us for a long time. I'll give you an example out of the technology space in relation to the electricity distribution network. I don't know how many of you remember when there was a power outage in Paddington for a number of days some time ago, for several days. It was about 15 or 16.
I'm from South Australia.
I'm giving the local content here, Adrian. You can do that. In any event, that happened. Now, the cause of that event, when they came to study it, was a 9-volt battery in the Haymarket that caused, because the systems were designed to fail safe, that used to fail the electricity system open. So what that led to was that a whole lot of power went to the Peterson, I think it was Peterson substation, which caused the Peterson substation to explode. That explosion wasn't controlled, a bit like an engine on a plane knocking out another engine, and that led to the bus bar failing. Now, the effect of that was to leave another surge of power that caused a rupture in an interconnect between two substations in Cannington, which caused the whole thing to rip up, which of course was an unsafe event. And all of this was due to the fact that people were doing maintenance on the main transmission lines across Sydney at the time, thinking there was relatively low demand, but this was on I think it was an autumn session where it wasn't terribly hot, wasn't terribly hot. Now, all of those events, if you look at them separately, they're all perfectly normal. A battery failure was normal, someone coming to replace them on time. Another event failing, that's normal, the system's designed to do it. But the confluence of all of those unanticipated and seemingly improbable consequential events caused catastrophic damage, led to a blackout for days with a number of houses. Hospitals were out of power, various other things happened. And it was the fragility of the system that had been designed that those kinds of events hadn't been anticipated. Now, as we're learning all of this, we probably do something about it, but it does illustrate the problem. We don't know the consequence of everyone going to one cloud, another cloud, or a series of clouds, using the cloud as a way of optimising our infrastructure usage, whether that's going to have the same sort of societal impacts. And bear in mind our dependency on technology, that's obviously something we should start studying on.
Have we got more time? Are we done? Always conscious. 5 more minutes. Oh, he's not. Oh, bonus time. Well, so in my view, and as an investment to this view, is that he says that the way of preventing this is one, you need skin in the game. Two, you need to have the right people paying attention to when they're building this. So this comes back to it's emergent. So someone is going to build the next, like the first, $100 billion legal tech company that is 10% of the worldwide market. Now, whoever builds that, they need to have skin in the game. If they're just, it's a whole bunch of people who are dispassionate and have, are either just trying to meet some VC targets or following authoritarian government's dictates, they're going to build it totally different to someone that has a passion about the law and following the rule of law. And so having someone build something with the skin, with appropriate skin in the game, that's the first way of stopping such a catastrophic event. Secondly, you need to create skin in the game against the people directly. I'm going to say something that could potentially, hopefully, put my head in the news in 20 years' time, but I think it's important that we put our skin in the game. I think that if you create a legal technology company and you create a systemic risk, that should be an offense. Just like I think if you create a systemic risk for banks, and then the government needs to bail out, Bear Stearns, crashes things, none of those directors got into trouble. They got sued, so on. They lost their jobs, so on. There should be a particular offense that if you cause a systemic risk to the legal system. Now, people who are building things are the best placed to recognize this, recognize the risks, and deal with them. So you're aligning their personal risk against them and the risk to the general legal system. Now, the likelihood of anyone getting in trouble for that is probably low. Hopefully you don't have any systemic risks. Now, at the moment, the legal system is very distributed. Most people, 80% of lawyers, I think, are sole practitioners. So there's very little systemic risk, rather than the court website. But what happens if you have a practice management software that is integrated with 80% of law firms, and then suddenly it deletes all its data, everything, for everyone? That's a systemic problem. What happens if you've got trust account management software that is across 50% of lawyers, and it sends all of the money to Zimbabwe? Like that's huge epic problems, and the way of preventing that is piercing the veil and looking directly at the people who control it. What do you think?
I think there are those kinds of solutions to the problem, and understanding the social organisation of legal practice and the organisation of the services that are consumed by those practices are very important considerations.
So there's a total difference in regulation of a financial planner who might steal money from the client or not take it in their best interests, and a bank. You shouldn't regulate in the same way.
A practical example in the legal space is understanding if you want redundancy in the retail supply, understand whether you have real redundancy or not, because as firms for a while will take a second supplier from a different supplier, but as the industry is consolidated, it's becoming harder and harder to find another provider that's truly independent and parts are truly independent. And that can be a very difficult process. But if you are committed to trying to reduce that kind of fragility and dependence and ensuring that that's a consideration, and I think whether that's creating systemic risk, but if you turn it around and say, when you design products, when you release products, just as we release microorganisms or others, you have a very serious ethical and social obligation to ensure you do the best you can and that you build for safety. You actually build, in this case, for security or for reliability or for resilience. And if you're not, then as we start to formulate those ethical rules, and those ethical rules become normative rules and become law, then it's very important to start thinking about one response is to regulate for systemic risk or creation of systemic risk. But the other problem about that, of course, is what does that mean? And how do we regulate something that's nebulous?
Well, so I think that you shouldn't try and extend present legal regulations like a blanket from one side of the bed to the other. You should say, here is law, and it works reasonably well, at least, in maintaining the legal profession, just by virtue that we're not in abject chaos. So things are not extremely terrible, like keep them going for regulating lawyers. Maybe tweak them, whatever, that's not a problem. But I don't think it's a blanket that you can just take over because it doesn't apply to lawyers, to law firms. So like having uncertainty as to what constitutes legal advice, or the example with crypto, how you conduct a trust account, like doesn't help a technology company and purely stops lawyers from doing it, because a lawyer says, oh my gosh, there's uncertainty here, there's no way I'm touching this. And then the technologist says, hey cool, like let's give it a try, it's a gray area. So what we're doing is we're ensuring that the people who are like us don't create the technology that's going to shape our legal future. So what we need is like following basic principles of law. We need certainty. All law needs certainty. So you should either say no, like Google's banned, everything's banned, it's bad, or say it's good. Like be clear. Like make a choice. I don't care where that choice is. I don't mind making great cool stuff, whatever the choice is. But have the option for creating a sandbox and say, hey, anything that's new is okay for 5 years, or if you tell us about, or we can do a regular sign-off and say that's okay. Then lawyers will be the people who can say, now that I have some certainty, I'm going to create something, and I'm going to create this technology with the principles and morality that I have that are impressive in that technology.
Maybe we take some
questions.
questions?
Yes?
Sure. A very interesting talk because it's an issue. Very interesting talk because it's an issue that actually comes up a fair amount in areas where I work in. I was having a discussion with a client just yesterday around reliance on machine learning outcomes. I think an area potentially where the regulators have missed, and I believe it's an access to justice issue as well, is the you get what you pay for principle. In that, for example, free advice, in my view, should be held to a lower standard. In that we know that there's vast masses of people who aren't able to access affordable legal advice, and they need a bicycle, not a Rolls Royce. And in those circumstances, I believe there are many use cases where close enough may very well be good enough. It's extremely expensive to eliminate systemic risk, is it requires addressing all edge cases, and addressing all the edge cases requires a ton of work, as we all know. And I think where we're dealing with, where there's an opportunity for informed consent by the consumers of those legal services, we as lawyers need to be more open to risk-sharing arrangements, so long as everyone's fully consenting with what the situation is.
Could I go first? So I think with, I agree, and in the consumer space, I think it's a problem of legal services where we get tripped up. So is Google legal services? That's where people, as Michael said, that's where 85% of people start, or lawyers start. So is that legal services? Now, people are going out and searching that, and that's not currently subject to regulations. Now, like 99% of legal decisions are made without a lawyer. If you're driving at 61 kilometers an hour and it's a 60K zone, are you breaking the law? You're going to make a decision. Do I slow down by a K? Is it allowable? You know, should I park here for 3 hours? Like, should I kick Michael in the head on stage? Yeah, no. Like, that's a terrible idea. That would be assault. I haven't gone and spoken to a lawyer who got advice that it's not okay to hurt people, or speak. I made that decision myself. Now, my risk profile is very different. I'm facing a number of different risks all at once. I've got a business, I've got sales and marketing, and customers, and employees, and some legal risks. And sometimes it's bet the farm. Sometimes it's, I'm going to throw everything at it. But most of the time you go, you know what, I want like an 80%. So you want to be able to, now for a lawyer though, a lawyer has to do 100% every time. I don't think we should change that. Because as a lawyer, you are doing a game, a repeat game. If you are 99% good over 10,000 interactions, you will eventually screw up, and that's really bad. You will damage your reputation, which is the thing the lawyers care about the most. So instead, what we should do is just accept that if you're a consumer, we should allow consumers to give them information so that they can make a decision themselves. That also brings them into the legal system. They otherwise wouldn't be in the legal system. They start off on Google, they go to Jade, and then go, let's brief a lawyer. Now that I've read something about this. Like I see this with Ailira, people come in and ask a question, they go something like that, and then they generate a document and go, cool, let's get a lawyer, review it. And then you say, now the lawyer is going to give you solid advice. And this is something that's covered by our identity. This is 100%. He's giving me a hand thinking about it.
Actually, I take a different view, and I agree with you. I think it's actually a very important conversation we need to have about what it means to deliver legal services and the law reform, the uniform laws that exist around. It's very hard to work out what it means to practice the law and give legal advice. It is done with respect to the drafting in such a nebulous way that it's almost like you know when you see it. And in the edge cases, it's a very difficult issue. And I think we need to have a thought about whether services, the provision of legal advice can be delivered more efficiently and in more accessible ways, and ways that are better matched to the needs of the people who are being delivered. And one thing that's clear from the legal profession, it's always been the case that one size doesn't fit all. So I think we need as a society and as a profession to just have that kind of discussion. And it's a tension that exists between sole practitioners, large firms with resources that are able to experiment about delivery of legal service in a new way. Sole practitioners see their market being eroded, an example being, of course, in conveyancing in the old days, there were licensed conveyancers. So the profession is undergoing a huge amount of change at the moment. There are barristers on one hand. What is the role of a barrister? Is the barrister a consultant, or should the barrister be allowed to have direct access, which the barrister can? What does that look like? Can a barrister receive funds in trust? Answer, yes, that is emerging now. But why? Because these roles, the complexity of the legal profession, the organism that is the legal profession, is a very important, I think it's really what I'm saying, it's a very important way to experiment what it means to practice law, what it means to practice law acceptably, and what it means to maintain the dignity and the position of the profession. And that's an important part about access to justice. It's plainly clear that there is a whole lot of unmet need in the profession. A lot of lawyers give their time freely to legal centres, to community legal centres and the like, and there's a whole lot more need that is needed to identify. People don't even take that first step. We need, as a profession, it's the ethical part, we need to take steps to do something about that. Because if we don't, then the legal profession will become irrelevant. People will find those solutions in different ways. And going back to the rule of law point, the rule of law depends upon respect and dignity and the ability of people to air their grievances in a public and open way, and to have those disputes resolved in a systematic and thoughtful way that respects the authority of the state and also individual, in the relevant case, individual authority. So, obviously criminal law is a different set of tests, but, why not in other areas do this? Anyway, that's it, my soapbox.
I think that's good.
Yeah, that is good. I've got a quick point on there. I think that's a good point you're making, that the unauthorized practice of law really, I think, presupposes that all the people who need legal services are getting legal services right now, and that's very much not the case. People who are getting no legal services would be very happy with some level of legal service, whether or not it meets that test. And then on the other side, those who are receiving legal services right now, perhaps we should start considering some of them to be sophisticated legal consumers. Maybe they don't necessarily need the same level of law pushing on them right now because they know the risks that they're taking.
And they don't
That's right. They're happy for 80%.
I'm making my central point is a very simple one. It's that for services, if you can call them that, I'm a tax lawyer, so my definition of services is I'm thinking GST. So the provision of services through legal technology, the risks from it are totally different to that which you would by the provision of services by an individual. So the risk of, so just think, an individual might not pay attention to a question and give the wrong answer, and they can screw that up once. So therefore, the penalties seem to be reasonably okay, at least for dealing with that and discouraging that kind of negligence. On the other hand, the risk for technology is that legal technology is that it repeats that 10,000 times. Now, the ability to sue it for one mistake is not going to prevent that harm, and the remedy is going to be a tiny fraction of that amount. And as I've shown, we're applying the regulation that you would apply to a human, which has a much lower distribution in its risk curve, is much more normally distributed, doesn't have the long tail. Something that's ordinarily distributed, it's not. Those regulations don't stop the systemic terrible harms. We need to, we need to look at it and say, hey, there is a potential for something terrible here. Not only should we not hold things, but the regulations are exactly wrong. Don't cover, they hold things back and don't pick up on the risk. People are going and Googling stupid stuff and no one's stopping them. There should be something.
All right. That was awesome. I thought that was a really good conversation. Can you please join me in thanking Adrian? Now, you stay up there. And we've got two others that are coming up. We've got Sam coming up, I believe, and Christina. All right.
She showed me the sneakers are going to be served first.
That's a good call.
Are we standing?
Standing, yes.
Never met you before. You can stay in the model area. Yeah, I think that's the thing. Stay there all night.
Now we can walk around it.
Oh, so let's walk around. Okay. We're going to walk, we're going to talk. Yeah, that's right. Does anyone want to talk
talk to us. There's some incredible stuff that Joseph has been doing, and you've heard all about that today. Joseph, do you want to talk about that?
Yep.